Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Matthew Hall, and today's episode is what is happening with class claims in the UK, the competition law opt-out collective actions regime. 10 years on from its introduction, and with tens of billions of UK pounds in damages now claimed, we'll be discussing the status and future of the regime. Our guest today is Jeremy Robinson. Jeremy is a solicitor at law firm Harcus Parker in London. He's a competition and regulatory lawyer with a practice spanning both contentious and non-contentious matters. He's represented clients before EU and UK regulatory and judicial bodies and has particular expertise in competition damages litigation, merger control, aviation regulation, and public procurement. Hello, Jeremy, and welcome to the show.
Hello, Matthew. Delighted to be here.
Well, thank you for coming on. So, Jeremy, let's start at an outline level. Could you just take us through the history and current status of the UK competition law collective regimes so we just set the scene? Absolutely.
It's important to remember, I think, to start with, that competition damages litigation in the UK is only about a generation and a half old. And the collective actions part of that is, as you said in your introduction, only about 10 years old. And one thing that's particularly interesting about that is you'd have thought that in a period of 10 years, you would have had a very, very substantial amount of movement and progress. And that certainly seems to have been the position that the government has taken recently. But in actual fact, if you look at the first 5 years of that regime, very little happened. And that's because one of the first cases to be filed, Walter Merrick's against MasterCard, certification was initially refused and was not finally granted until about 4 or 5 years after the case had originally been filed. So for half of the period that it has been in place, we have had very, very little movement. Since then, there has been an explosion of cases. A large number of mainly opt-out, mainly standalone cases have been filed in the UK. Some of these cases have now settled. And we have had recently, in the last month, a full judgment finding both liability and awarding damages in the Kent and Apple case. So we're now at a stage where the regime, I suppose it could be described still as an adolescent. It's no longer embryonic, but is beginning to mature and mature rapidly.
Okay, that's a good background. So for our wider audience, Jeremy, in focusing, as we say, on the opt-out competition regime, what are some of the points we should be aware of in terms of, you mentioned certification, of course there's funding, there's the question of direct and indirect purchasers and kind of the nature of what opt-out means in terms of signing up and distribution. So maybe a bit more detail on those areas before we move on.
Absolutely. I think the premise of your question is about opt-out collective actions. But the regime that was actually created in the Competition Appeal Tribunal, which I'll call the CAT, or the tribunal, the regime that's been created provides for both opt-in and opt-out collective actions. And I want to preface what I say by saying there have been some opt-in cases brought. One of these is in the trucks litigation, the Road Haulage Association claim. And the other two are actually part of the same litigation known as CICC against MasterCard and Visa, which is unusual, in fact, perhaps unique in that it is a hybrid structure of opt-in claims and opt-out claims. I think one thing that people need to be aware of in the UK regime is a lot of work for claimants is front-loaded. The certification happens almost immediately within the timetable, not immediately in sort of pure chronological time. We're not talking about days or weeks after filing, but it's the first major stage is you have to pass the certification test. The certification test, the courts have told us, is not a merits-based test, but I would describe it as a very, very heavy procedural test that looks at the organization of the class action, the methodology, the suitability of the class representative, the funding arrangements, both the adequacy of the funding arrangements and the relationship of the funder and the class rep and the rest of the team. So it's, as I say, it's a very, very heavy procedural hurdle that some cases have struggled to overcome. It can be combined with an early doors merits test via reverse summary judgment or strikeout, and there have been examples of that. Following that, there are some issues which I think were not statutory at the time they were initiated, but through the CAT's case law, certain points have evolved to a high degree of prominence. For example, in an early case involving Meta, the tribunal decided that a methodology, a blueprint to trial, that needed to be adequately articulated at the certification stage. And it found that in that case, the class representative had not so articulated it, gave the class representative an opportunity to fix that, and it was certified the second time round. The same in the CICC proceedings. And again, that was corrected the second time round. So this requirement for an adequate methodology based on the Supreme Court of Canada's jurisprudence in Microsoft and Process has become very important. I think we've also seen a lot more attention given to the class representative, and in particular the class representative's ability to manage the class action in the best interests of the class. And that requires ability to manage the team that is appointed, so the lawyers, the economists, and the other parties engaged in the litigation, but also independence from the funder and ability to put the interests of the class as necessary, separate from the ability of the funder to claim a fee at the end of it. And related to this development, which was articulated in a very important case last year called REFA, has been the growing focus on distribution. We haven't had a long-term experience with competition law class actions in this country, and we have a CAT regime that's focused on competition law. It doesn't involve directly issues of consumer law or data protection, except so far as they relate to competition law. So we don't have a culture whereby consumers are used to claiming damages in part of a class action. And this creates a very, very serious problem for the ability to distribute damages and opt-out cases to the class. And there was a case very recently involving trains where the defendants settled with the class representative a reasonably significant sum of money. And there was a provisional division of that pot between the different stakeholders, being the class, the funders, the class reps team. And the tribunal noted with great disappointment how few people had come forward to collect their damages. It was a tiny proportion of the overall pot made available. And this causes questions about the legitimacy of the regime and in whose interest it is operating. So the tribunal has made very clear that in future opt-out cases, a lot more thought needs to be given up front in this heavy procedural certification review to how any resultant damages are going to get to the class at the end of the day.
Yeah, that was an interesting one. That was the Justin Gutman claim. And I saw an interview with him where he actually admitted, he's the class representative, he actually admitted that there was, quotes, a grave problem with distribution in that case because they couldn't identify who the holders of the tickets that had, he claimed, overpaid for their train tickets actually were. So, as you say, that maybe should have been thought about a bit earlier than that point. And it's also, I think, important to before we move on here, Jeremy, to confirm that we've referred to follow-on and standalone claims. Most of these opt-out claims are, of course, in fact, standalone claims, which do not rely on an infringement decision. And also that the regime can cover both direct and indirect purchasers. And we've seen claims from both levels of those claimants.
Yes, I mean, I'd probably add to that in relation to follow-on versus standalone, it seems the government thought initially at the design stage of this regime that there would be far more follow-on cases. There have been a few, but few and far between, as it were. And I think there's also an assumption that the paradigm case for this type of regime would be a follow-on case after a cartel or some form of restrictive agreement. The surprise has been not only that most of these cases have been standalone, but that they've been based on abuse of a dominant position, and very, very heavily in the tech sector. So some of the defendants have now had the dubious pleasure of being defendants multiple times now.
Yeah, I guess maybe their deep pockets are relevant to that issue, as well as, of course, their alleged behavior. So you referred briefly earlier to a recent successful claim. So this is actually the first case to reach a successful, i.e. damages awarded conclusion at trial in the UK. This is Kent as the class representative against Apple. So could you give us a bit more detail on what happened there and what we learned from that case, please?
By all means. The Kent and Apple case is an interesting one. It was one of the earliest cases filed under the regime. It's filed in May 2021. It was certified almost a year later, so May 2022. And so we now got the judgment October 2025. So it's, first of all, interesting for the speed with which the CAT went from certification all the way through a very extensive trial in January, February this year to come out with an extremely long judgment 8 months later, which is comprehensive. And at its core, the case is an abuse of dominance situation where the CAT found that Apple enjoys a position of almost total market power in the iOS app distribution services market and the iOS in-app payment services market. And in those markets, the CAT found that it had abused that dominant position without objective justification through foreclosure abuses, in other words, requiring apps to be distributed only through the App Store, requiring the app and in-app purchases to be using Apple's own payment system. There was a tying abuse there. There was also excessive and unfair pricing for the commission that is charged, which is a 30% commission. And this is particularly interesting because competition lawyers are well aware of the challenge of proving excessive pricing. By what measure? The CAT there used the standard United Brands test, which it applied, and it found that the prices charged, the commission charge was excessive as measured in the price difference between the costs over the claim period and the actual prices charged. And it was unfair in and of itself, and by reference to specific named comparators, being Steam, Microsoft Store, and the Epic Games Store. And they found that the claimed efficiency gains that come out of this, the enhanced performance and so on, didn't really matter. For example, the impugned conduct of Apple essentially eliminated all effective competition in the relevant market. So the CAT had no time for that. Then interesting, the CAT then went on to calculate the damages which it found as the difference between the 30% charge and what it found would be the competitive level of 17.5%, to which it applied. Then it had to apply the pass on. So you mentioned earlier this whole direct and indirect purchaser question. This is subject to substantial litigation in the UK at the moment, in other cases as well. And here the CAT was faced with widely divergent views of what that pass on might be between, say, 10% and 90%, and pretty much drew a line in the middle using its wide discretionary power to say, well, we think it's about 50%. So 50% is the pass on level, and then it applied interest at 8% on top of that. So I think the case is notable both procedurally. I think it's a landmark judgment to have sort of incorporated all of these elements into one judgment. And I think it's quite important because there's been a bit of a drumbeat since, in fact, before the regime came into effect, that maybe this is just a regime which enables unmeritorious and speculative litigation to be brought, essentially a shakedown of deep-pocketed defendants, to use your phrase. And here is a judgment where the CAT has very robustly found an abuse of dominant position in the UK and has gone on to calculate the damages and the pass on. So I think it's pretty much landmark.
as you say, it goes through all aspects of this. And in this case, it presumably should be easier to identify the actual end users who will be compensated because all the data, I imagine, is there, unlike the train case where they have no idea who actually bought the tickets.
Well, that's true. And given recent statements from the CAT in one case that came out in the last couple of weeks about the importance of working this out at certification stage, certainly it's a consideration for claimant lawyers right now to think, well, what are we going to do about distribution? It's not only a question that you have to have a clear class definition so that people can ultimately determine with help whether or not they are a member of the class, but you also have to think, well, how are we going to get the money to them at the end of the day? And in some situations, of course, the CAT has to weigh competing interests. So, for example, if there is a solution which provides for an almost perfect distribution to the class, so there's no question of low take-up, you're going to get 100% take-up, there's the question of what is the fair return to the funder, because the CAT is very recognizant that absent litigation funding, pretty much all of these cases would not get off the starting block. And so the CAT recognises that the funders should get a return on their investment, but of course it must be sensible and proportionate. And you can't have a situation as you have in the trains case where there's a massive disparity between what the class is able to get and what other stakeholders are able to get.
Yeah, we'll get on to funding issues later and also the UK government's review of the whole opt-out collective claims regime. But before we get to that, Jeremy, as a practitioner in this space, so leaving aside funding, what do you see as the main, we touched on some of these already, of course, but what do you see as the main headline issues about how the regime currently operates, the problems from both sides?
From a claimant perspective, there are a number of hurdles to overcome. One, as you say, we've talked about this already, but the certification threshold, there is a perception that because certification is not a merit-based assessment, therefore it must be easy and that the bar to certification is low in this jurisdiction. I wouldn't say so at all. It's a very, very substantial preparatory process that's very, very, very costly, and the tribunal can raise questions of its own motion as well as respond to points that were raised by the defendants. It's therefore quite a costly thing to do up front. The second thing is there has to be transparency over the cost and the funding arrangements on the claimant side, which is, of course, absolutely right and proper. There is no equivalence in relation to the cost that the defendant may incur, which is relevant because, of course, if you lose hearings and you have to pay the other side's costs, what assessment is there going to be of the reasonableness of those costs? So from a claimant perspective, there's an imbalance there. At the certification phase, claimants have to put all cards on the table as far as how they plan to run the litigation, covering everything from economic methodology right the way through to distribution. But there's no equivalent duty on defendants to put all their cards on the table about what arguments they might intend to run. And from a point of view of a regime that should be incentivizing parties to enter into discussions as soon as possible to avoid the costs of litigation and the time taken, the judicial resources, from a claimant's point of view, that is somewhat unbalanced. One of the things that relates to that is that there is fairly substantial ability for defendants to raise every single point and then expect that to be dealt with, but at the same time complain about the costs that then arise. So this satellite litigation issue, of course, is prominent and gaining in importance. I think from a defendant's point of view, and I will limit what I say here because I act mainly on the claimant side, but from a defendant's point of view, as is apparent from some of the more public debates about the future of the opt-out regime and funding and so forth, there is the sense that these actions are almost not by definition, but almost all unmeritorious and shouldn't be brought, that the level of funding available in the market is excessive, and this creates an unlevel playing field because funders are apparently too willing to give money to speculative cases, whereas defendant clients are able to pressurize their law firms to operate on a highly efficient basis. It will not surprise you if I say that I don't support that argument.
As you say, there's been a lot of satellite litigation, so a lot of things during the first 5 years or so were really kind of dealt with in a lot of detail as the regime kind of bedded in on representative issues. You refer to unmeritorious. We don't need to talk about this much, but there's certainly also been discussion about whether claimant lawyers, as you say, you are primarily a claimant lawyer, been trying to squeeze what are really consumer protection type claims into this box, because of course opt-out claims like this are only available for competition law issues. So do you want to make a brief comment on that before we move on to funding?
Yes, by all means. There has been this concern about, we call it shoehorning, where because we have a regime that's exclusively competition law based, other issues can then seem to lack some kind of natural remedy. So the argument is that some cases which are more properly described as consumer cases or data protection or even intellectual property get squeezed into a competition claim, which can then be brought and take advantage of the opt-out collective actions regime. I think the CAT has been quite robust and clear and in distinguishing between what is, shall we say, a competition claim that has a consumer element or a data element, for example, the Meta case, or recently there was a case involving copyright, and the question was, well, surely the copyright law issue should be dealt with by the High Court, and the competition part could carry on in the CAT. And the judge in that case said, actually, there's no problem because this is properly a competition law case to which the copyright part is secondary, and there's no reason why the judges of the tribunal should be unable to hear that part. So I think it is an important point for claimants and claimant-side lawyers to be aware of at the conception of the case, how it is to be framed and whether it is to be properly described as a competition case. And I think it's one of those ones where you know it if you see it. You can tell whether it's being a shoehorned case or whether it's genuinely a competition case that just happens to involve elements of other areas.
Yeah, you can tell if it's artificial. That licensing case I think you're referring to is the Microsoft case where there were various copyright arguments.
Yeah, I think it was JJH. Yeah.
So moving on to funding, of course, none of this really happens or can happen without third-party litigation funding. You could probably have a whole episode on this issue, but so briefly, Jeremy, can you take us through what's going on here? Of course, the famous PACCAR Supreme Court judgment has cast a long shadow. So where are we now on litigation funding in this space?
So the PACCAR ruling really upset an awful lot of people, and it upset long-held assumptions about what would be lawful litigation funding and what would not be. And the context of that case was that funders in an opt-out case were due to be remunerated on a percentage basis. So they would get a percentage return on their investment. And the first instance and Court of Appeal accepted that this was acceptable within the DBA regulations in the UK. The Supreme Court, however, turned it on its head.
Damages-based agreement regime.
Yeah, damages-based agreement regime. The Supreme Court, by a 4-1 majority, overturned that and said that actually these weren't properly CFAs, they were damages-based agreements, and because they did not comply with the specific requirements of DBAs in the UK, they were unlawful. And this threw the funding industry into a spin, it threw a lot of claimant lawyers into a spin. And a number of things happened thereafter. First of all, there was an abortive campaign to lobby to have Parliament legislate to overturn the rule in PACCAR. And that foundered because before that one-line bill could be passed, then government of Rishi Sunak was dissolved, and we went into general election, and that draft legislation fell and has not been revived. The second thing that happened was that the then Justice Secretary, Lord Chancellor, commissioned a review into litigation funding in the UK, and I'll come back to that in a second. And the third was that a number of these collective actions in the CAT then had to restructure their funding arrangements to get around the rule in PACCAR, so that instead of a percentage return on investment, it would be a return calculated as a multiple of the capital deployed. And then this led to another great example of satellite litigation, because those funding arrangements were then challenged before the CAT. And in those cases, the CAT had no difficulty in finding that the new funding arrangements would not offend against the rule in PACCAR. This then got booted up to the Court of Appeal because the defendants, who then became the appellants, challenged that on 4 separate grounds. The Court of Appeal earlier this year unanimously threw out that appeal. Some of those defendants then applied for permission to appeal to the Supreme Court, which then refused that permission to appeal, saying there was no arguable point of law. So on the satellite litigation front, the position seems to be clear now that a return calculated as a multiple of capital deployed would be acceptable. It doesn't do anything about the original rule in PACCAR, and there's, of course, a question of which is better for the class, a multiple of capital deployed regime or a percentage regime, but that's a separate question. But the CJC, the Civil Justice Council, then reported earlier in the summer, and it made a number of recommendations. And high up amongst those recommendations was that the government legislate to reverse the rule in PACCAR. And this was the cause of much rejoicing in the funding and the claimant industry, saying, fantastic, we'll get clarity here. But there was a sting in the tail, because although amongst those recommendations there were a number of sensible suggestions for how litigation funding could be better regulated or better organised in the UK, with which I think most people would agree, there was what is now becoming a notorious Recommendation 21, which related to how these opt-out cases are to be originated. And the suggestion there was that the solicitors acting for a class representative be required to certify that essentially they had not originated the case. And thus, the only cases that could be brought in the Competition Appeal Tribunal would be those that had been, somehow emerged from the ether or from very, very observant potential class representatives bringing their cases to claimant firms. And I think the practical effect of this would be to vitiate all of the other reforms in that. And so I argued against that in a blog that I wrote back in the summer.
Yeah, we'll put that blog on our website. I read that with interest. I mean, leaving aside the Recommendation 21, which, as you say, is very, very strange. Why this particular area could lawyers not and funders not seek clients, basically? Where do you think that came from?
My sense is it came from a fair amount of consistent behind-the-scenes lobbying that predates even the Consumer Rights Act 2015, because I think at the bill stage, there were a number of corporates who were, as you understandably, implacably opposed to any kind of reform that potentially put them in the firing line as potential defendants. And so there's been a considerable concern, not only here, but I think across Europe, that the introduction or the promotion of private enforcement of competition law would lead to a claimant free-for-all, would lead to these unmeritorious cases. And I do remember the debates more than 10 years ago around the EU Green Paper about the importance of avoiding what was called the excesses of the US litigation culture. And so the idea of trying to attack this regime from multiple angles at once, one by challenging all kinds of points in satellite litigation, another by challenging the specificity of the funding arrangements, another by challenging the very legitimacy of litigation funding at all. So I don't think it's hard to see where this comes from. The question is, to what degree are those arguments made out and balanced?
Yeah, interesting. I mean, I guess anyone who's driven around the US will see billboards all over the place, right, with claimant lawyers advertising on particular issues. So maybe it would stop that, which may not be a terrible thing. But leaving Recommendation 21 aside and briefly here, Jeremy, even if PACCAR is not overturned by legislation, is your view that the new acceptable method with multiple of funding is actually working fine for the funders and the claimants?
I think it's probably too early to answer that question definitively. And I think for a balancing view, you should probably invite one or two funding industry representatives to answer that. Time will tell, Matthew. Certainly in relation to the case that I'm on, that takes away the uncertainty that would have otherwise persisted over the funding of that case. So that's helpful. It may persuade some funders who might be sitting on the fence that the UK is a good investable regime for this type of action, albeit it's an expensive regime, but nonetheless it's one that is capable of coming out with results, and it is at least tolerably predictable as regards funding. But I do stress that I think time will tell, because with a number of the developments we've talked about in this conversation, we are at an adolescent stage in the development. I think let's have a look in 2 or 3 years' time to see, first of all, what exactly was the chilling effect after PACCAR and before this current ruling, and what has been the uptick.
As you say, an adolescent phase, and as I mentioned, it was 10 years ago that it all started, the opt-out collective actions competition law regime. We've referred to this already, but 6 August 2025, the current UK Labour government brought out a call for evidence on the regime, specifically on this regime only. It's now closed, and you wrote a very interesting blog post on this, which again we will have our Curious Amalgam webpage. So could you just take us through briefly what that call for evidence is all about and the points that you were making in that pretty punchy blog post from October 2025?
Yes, by all means. In the short point is that the government decided that after 10 years since the Consumer Rights Act came into effect, now was the right time to assess whether the regime was working, and if so, what could be done about it. And I reacted somewhat strongly to some of the premises that the government used for framing the discussion it wanted to have. And actually, I felt that a lot of the consultation questions therefore missed the point. What it was saying was that, first of all, it was the right time to review, and 10 years was somehow a good indicator of that. But as I said, I think at the top of this hour, given that half of that period was taken up with appeals up to the Supreme Court on the very first case to face certification, I don't think that's representative. But then a lot of the rest of the consultation talks about some kind of balance that needs to be struck between the interests and the rights of consumers to getting effective redress and the rights of business, and business is sort of somewhat ill-defined. And this balance frame, I thought, was ill-conceived in that there's no essential tension between the two, and it misses out an awful lot besides. So the case I'm on, the CICC proceedings, is a business-to-business class action. Some of the businesses we represent are very, very large indeed, and some are tiny, and everything in between. And so if we were to be successful in our case, is that a victory for business, or is that bad for business, or is it just bad for the businesses against whom we have brought proceedings? So I felt it was somewhat ill-defined. And then there's this vexed question, which I think has interested UK practitioners a lot, about what is the relationship of this government and economic growth? What do they mean by, how do they intend to use competition law, or steer the enforcement of competition law to achieve economic growth? And there are practitioners who can talk about how steers in relation to merger control or antitrust have affected the output of regulators. But when it comes to private enforcement, the underlying suggestion seems to be, well, we've had a lot of lobbying from business who say it's really, really bad to be faced with these a priori defined unmeritorious actions. Can you do something to stop it? And the government's said, well, we have to balance that concern against the rights of consumers. And the oddity in all this is that when the Competition Act was passed in 1998, and the sort of discussions leading up to that bill, and then the discussions leading up to the Consumer Rights Act, lots of these reforms, which increased the jeopardy for potential defendants here, were framed in terms of promoting dynamic markets, which is good for economic growth. And now it seems the government was implicitly rowing back from that and saying, well, maybe too much competition law enforcement is bad for growth, and therefore we need to find a balance. So I reacted sort of quite strongly to that. And I think actually if the government starts from the perspective of, well, we need to have growth in the economy, I think they needed to remind themselves about why the Competition Act was brought in and why private enforcement is essential to complement public enforcement, which can never cover all areas of the economy and all potential infringements.
As you say, competition law generally seen as enforcement, generally seen as being pro-growth, and current government certainly putting its hand on the scales in other areas, not least merger control and general enforcement, not necessarily to the benefit of that area. So that blog post is definitely worth a read in my opinion. So Jeremy, before we move on to the final section, what you referred to this, but what do you think would be the reforms, if any, that should be put in place, to assist and improve the opt-out collective actions competition regime?
I don't think major statutory reforms are needed. I think what would be helpful would be the secondary legislation, the CAT tribunal rules. I think most people would accept it's time for an overhaul alongside their guide to proceedings, which have been the Bible for practitioners in this area for 10 years. But I think some of the developments, particularly around what a class rep is supposed to do, what the requirements are for methodology, what the requirements and the expectations are for distribution, for funding, and so on. I think all of those could be clarified in the rules, essentially to codify the case law that we've got to. I think we're well overdue that, because I think ultimately, from the helicopter view of the regime as a whole, the balance that we should be looking for is a fair balance between the rights of claimants and defendants to pursue and to defend litigation brought against them. I think we do need to work on a way to make these proceedings more efficient from the judicial resources point of view, from claimants, from defendants, so that ultimately it can be seen that the real winners out of this regime will be the class members in duly meritorious cases.
Yeah, so I think you're saying it's really most of it can be dealt with, if not all, without actual legislation. But we wait to see what happens following the conclusion of that review.
Yes.
So great discussion, Jeremy. Thank you very much. We like to finish these episodes, as you know, with some personal questions. So firstly, could you please tell our listeners something interesting or unusual about yourself that we would not know from working only with you on a professional basis?
People who do know me, my colleagues in the office and friends know me that as a lawyer by week and a musician at the weekend. I'm a jazz trumpeter. I play in a few bands with different musical emphases, some on early 1920s, 30s jazz, some on sort of 60s and later.
Fabulous. So I guess you've been playing for a long time, since you were a child, and you've carried on.
Yes, I somehow never managed to give up, but actually I practice more these days, and I greatly enjoy going out and gigging and exploring it. It's somewhat different from appearing on a podcast or advocacy or any of the day job, and it's a great relief, but it's also personally challenging in lots of different ways.
Excellent. Well, we'll look out for you in a jazz club next time we're there. Now we have our Curious Hat.
And now it's time for the Curious Hat.
So, Jeremy, I think you know how this operates. We ask you to choose a number between 1 and 10, and we select the question based on the number.
6.
So from the virtual hat, we are choosing 6. And the question is, what book are you currently reading, and would you recommend it to us?
I've just started reading A Life in Time, which is a biography of Dave Brubeck. So we were talking about jazz, so I've enjoyed listening to and playing Dave Brubeck's music all my life. It's so far very well written. The author takes a non-chronological approach. He sort of dives in the middle and then moves around, but it's early stages in that book. A book I've finished recently and greatly enjoyed was Concorde by the former British Airways chief Concorde pilot, Mike Bannister, which is a terrific read and interweaves his own life as a pilot, as a little boy who'd always wanted to grow up being a pilot, through his career on Concorde, right through to the end of the service of Concorde and his role in the investigation that took place after the sort of tragic Paris air crash in 2003. So that's a terrific read, and I definitely recommend that.
I agree with that. I've read that book as well. The technology that they put into the Concorde, designed and built at the time so long ago, was just totally extraordinary.
Yeah.
Thank you very much, Jeremy. That's been a great episode, and thank you very much to all our listeners.
Thank you, Matthew.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.